I think this is a particularly important theme to speak of legislating land sidestepping redistribution because of the elections in Gujarat. If you look at the kind of Dalit leadership that has now emerged, I'm speaking about Jagdish Mewani, seems to have turned the entire discourse of Dalit politics from identity politics to that of land, to that of income, to that of livelihood. So we've shifted from the notion of recognition to the notion of redistribution, which is an interesting turn in Dalit politics. So let us see what this new Dalit leadership brings us in the elections to be held. It is an extremely important topic because in countries like India, indeed in most of the global south, land continues to be the basis of power or lack of power. I look forward to these presentations, each of them 15 minutes. And we begin with Astha Saxena, who is going to present her work on the laws relating to land. She especially draws attention to the manner in which lawmaking has derailed the distribution agenda of law reform. How shoddy lawmaking can become a way of resisting social change. And she shows how bulk in law can also prove to be a technique of obfuscation, which is an interesting argument. Astha, 15 minutes.
Thank you, Professor Chandhoke. Good morning, everyone. After yesterday's session, I'm sure getting here at 9 would have been a tussle. But, well, we are starting with the first panel today. We call it Legislating Land Sidestepping Redistribution. Seems to be a heavy term. And before I begin with anything at all, I would first like to start with thanking Professor Dhanda there and my colleague Anandita Mukherjee, without whom I would not have been standing here at all. There was no chance in the world. In this project, we had these 4 thematic distinguishments that we had made between the 4 rights. So we had the right to land as one of the biggest agendas that we were trying to figure out what is the right to land, if there is a right to land that we have in India at all. And before we even begin to say that, or begin to understand the right or rights to land as the jurists most likely call it, we thought that it might be interesting to first know how is land legally placed within our circles. Land is a socio-economic entity, and it generally regulates, land relationships are generally regulated on 2 levels. So the first is between the state and the individual, and second is between individuals. So the state and individual dimension throws out about 1,100 legislations in the country, which are on state and central levels. And the second part, which includes all the legislations, the 1,100 that I'm talking about, is the property dimension, is where 2 people are contesting land with respect to when you understand land as property. That is a discussion for the second panel, and I will leave it there. That was only in order to flag the distinction. Okay, so when land is considered as property, there are huge differences, and when it is translated into property, especially private property, land being a socio-economic entity and saying that only one person will have claim to one parcel of land can be problematic. And that legal translation that we lawyers like to do very much, because it increases the contestations, is something that has sphered the imaginations all through. So whereas land, the socio-economic dimension of land is completely lost when you state it as mere private property and say that only one person can have claim to one parcel of land and not those were just some preliminary points that I wanted to make before I get on to the main part of my presentation. So for convenience purposes, we will divide my presentation into two bits. First, we will see how is land legislated? What are the sorts of legislations that we encountered? And secondly, we will see how were those legislations constructed to sidestep redistribution. It was a constructed effort in my opinion, and as we go through the legislations one by one, we would understand how did the redistribution agenda was faded by the law as it was being legislated again and again and again. This also gets us to a place where the nature of an Indian land law we might want to ascertain, because land is a state subject, and the diversity with which every state assesses its own land and its land relations, it has its own vernacular terminology. It's extremely difficult to get it on to one level and say this is the Indian land law. And possibly that is why we don't, in our legal textbooks, we refrain from doing that and we study only the state in which we are in. For example, if you're at NALSA, we usually study only the Andhra Pradesh, Telangana land scenario and not the Indian land law as such. So how we did it was we collected these 1,100 legislations and we divided them into thematic groups. Dividing it into thematic groups gave us three broad categories, which were the laws of reform, the laws of regulation, and the laws of acquisition. Now, once we had these three categories, we started creating tables, which we create a thematic classification and assess all those legislations across board. So for example, if we have ceiling legislations, we see how was the ceiling determined in each state and what was the outcome. So similarly, we created tables and we did this study saying just in order to assess and know what is an Indian land law if we have to call one at all. And all of this was done beyond, with the background of the right to property. Immediately after independence, when we had this huge agenda that land must be reformed and has to be redistributed, we did it in the background of a fundamental right to property, which was apparently inserted in the constitution with the idea that redistribution and reform must take place as soon as it was possible. And therefore came that bulk of land legislations, and we had tenancy reforms, we had abolition of intermediaries, we had redistribution, we had ceiling, you name it, and we had it. Land ownership at that point of time, when the first survey was conducted, was concentrated in 11.85% of the population. So 11.85, the National Sample Survey first report, if you see, we will realize that 11.8% of the population had land ownership. However, being an agricultural economy, every agricultural laborer, tenant, subtenant, occupant tenant, non-occupant tenant, the series of legal terminologies that we created for them were actually irrigating land. So the idea was to give them the land. And since, we can't create land anymore, so it had to be taken from the people of that 11.85%. And there came our right to property. Their right to property, the intermediaries, the landowners who believed that since the right to property could be used for them to take their land, to keep their land, it was not if the right to property was to be constructed for the agricultural laborers and the tenants and everyone else, every class of person who has any sort of economic relation with land, the right to property got segregated there. So I will again come back to, because it's a large, it's a very long discussion and I have very short time, so I will come back to that agenda. But that's in that background where the right to property seem to only belong to the landowners and not to the people who were to get land in the process of redistribution. Because while we did ceilings and while we said that land has to be given to the cultivators of land, we never created a legal right to land in that context. The right to property was taken up all by the zamindars and landowners at that point of time because they had the social and economic capital to do so. They litigated in the Supreme Court until Keshavanand Bharati, which then had to, it got into an entire different debate where the basic structure doctrine was created. When the core fact of that case, which was a land reform legislation, that they had to decide whether land could be given to someone else by taking from someone else, was just lost in that transaction. And they were very successful in doing it because it was possible. They had the social and the economic capital. Now, this was a law of land regulation. Sorry, that was law of land reform. And the law of land regulation is the second theme that we got from these legislations, which is usually land records, titling, the administration department, their powers, and how they are to regulate land. The third was the law of land acquisition. Now, the law of land acquisition comes with its own baggage. I mean, the first legislation was 1857, and now we have the 2013 legislation. However, when lawyers, or especially law students, study the law of land acquisition, we only see these two statutes and we say that that is the comparison to be made, and hence to figure out what the law is. However, in reality, both on the central and the state levels, there are about 80 odd legislations that allow the state to acquire land in various scenarios. Whether it is the municipal whether it is the municipal committee or any governmental body, the public purpose is defined under each of these legislations as anything that the government perceives that for which land can be acquired. So there is a section where we assess who is the public and public purpose. And again, when you translate the public purpose, when you take out the actual public from public purpose and see it only as a legal term, and say that it is in the benefit of common and for everyone. Who is the common we are not talking about? So these incessant land acquisitions that have been happening right after, especially the reform agenda failed in the 80s. So that is, so legally speaking, there are those 80 legislations that say that you can acquire land. Other than that, we created these two new land grants and land pooling techniques, saying that since consent is not there in land acquisition, maybe we can do it by other means. Whereas the actual process of land pooling and land grants is no different from land acquisition legally. It happens similarly. Only the consent element is taken out. That we can handle politically. That's not very difficult. So that's how we did the entire classification of land laws. Now the second part of my presentation is to say that. How was redistribution sidestepped? In this entire gamut, if the answer of every question is to make more laws, then I don't think land should be a problem because we have plenty of them. We have so many of them that you can't even find half of them. We once went to the Secretariat of Telangana and said, because one of their land reform drafts said that there are over 200 land legislations in the state of Andhra Pradesh and Telangana, and we couldn't find them, They were not there in the Gazette, they were not there in Manupatra, you name it, and we tried to, pinpoint them, and we couldn't find them. I could make a list of about 120. And we went to the Law Secretariat and we asked, sir, it says that there are 200 legislations, I can't find the rest 80. And he gives me this look and says, I think that those might be amendments. If you can't find it, that's the only place. So, because I have last 2 minutes, so I will just do the final part of my presentation very quickly. So when you say that redistribution was sidestepped, in my opinion, and I think the project findings say so, it was a combined effect of the utter failure of land reform agenda along with the excessive working of the land acquisition legislations. We formed the land reform legislations so that they could fail. We had ceilings without any provisions of redistribution. We had tenancies. On one hand, we were saying that tenancies should be abolished and everyone should be given ownership of land so that it is divided and it merges with the redistribution agenda. On the other hand, we created a clause called personal cultivation, which is very, very famous in law books and otherwise, which said that you cannot, if a landowner is personally cultivating land, so the legal definition of personal cultivation was whether you're doing it by your own labor or you're getting it done by someone else's labor. So if you're doing land and our ceilings went up to a good 60 acres. In Rajasthan, 60 acres was a very good ceiling to have obtained in those periods of time. And you are personally cultivating through agricultural laborers, having those 60 acres of land. Redistribution was just not possible. The most popular agenda of the state then was, see, we created all these legislations, but oh my God, we couldn't implement it because, okay, my time's up. We couldn't implement it because, you know, there is lack of administration and we couldn't do it. But all I want to say is that the law was not created for any effective implementation to happen at all. Thank you very much.
Thank you, Astha. Perhaps the one state you should look at where land was appropriated without compensation, the one state is Jammu and Kashmir, where there was no compensation, but that also caused, it led to conflict later on because land was appropriated from a certain class of people and given over. And the second problem was, of course, that orchards and plantations were not subjected to land reform. Our second speaker is Professor Michael Lipton. I leave it to you to decide how much time you want to speak, perhaps.
Thank you. First, I'm enormously grateful to Amita and her colleagues for inviting me to this conference. There's much talk of interdisciplinary work as of land reform, but much less action. And it's very good to see lawyers and other disciplines cooperating to understand these questions and at such a high level of discussion. Thank you. I'd also like to thank Astha Saxena for sharing with me her inspiring manuscript, which perhaps for the first time tries to classify Indian land legislation not in a mechanical way, but by object, aim, and achievement. And that is obviously terribly important and a precedent that needs to be followed elsewhere than in India. I'm going to divide my outline, my comments, which I will try and keep short, into 5 sections. First, the nature of property rights and land rights. Second, why what I call two different property rights to land, that is the right to incumbency and the right that land gives or may give to equal opportunity, why they both need to be taken seriously. On the whole, the right, in quotes, takes the right to property seriously. The left, in quotes, takes the right to equal opportunity seriously. We need to take them both seriously and to ask how they can be reconciled. Third, we need to have a set of guidelines for deciding when the incumbent's legitimacy matters more and when it matters less, and for deciding when equal opportunity for all persons in respect of land matters more and when it matters less. It's not that this can be put into nice commensurable terms. These are incommensurables, but that does not mean we cannot make progress. And then I would like to talk in the fourth section on negotiating progress towards land redistribution, and in this context, contributions from economics to law. And finally, I'm going to make a few modest and tentative requests from economics to law. First, property rights and land rights. Astha sees land as a special case, not to be subsumed as a form of property, because land does things for people and to people, not only through power, but also through providing access to food in agrarian economies and access to work, so sometimes access to life, and sometimes in the urban sector, access to shelter. In other words, land is special and shouldn't just be seen as a subclass of property. Now, that is very often true. As an economy becomes less agrarian in its space, so land becomes obviously a less crucial and solitary component for access to food. And most of these rights can be achieved by tenancy rather than by ownership, and sometimes by employment rather than by control of land. Nevertheless, they are important reasons in many societies for seeing land as different. But there is another reason why land is special. There are other reasons why land is special. Land is an unearned source of income. John Stuart Mill makes this beautifully clear in a section which I discuss in my book, Land Reform in Developing Countries. No one made the land. If you get income from your own work and from capital, no one has a moral claim against you. But if you get land because you inherited it from your great-great-grandfather, and somebody else comes into the world and all these claims are used up, then that person has a right to be morally angry. And that is a special characteristic of land that does not apply to other property. Further, a second special characteristic is that heavy local concentration of farmland control allows the village big man, and it usually is a man, to threaten autonomy of other people in a whole lot of other fields than land. Autonomy in employment, autonomy in credit, all these, and autonomy in obtaining a tenancy if you're not an owner. All these tend to be in the gift of one or a small number of local land big persons. And this is not only true of India, or very clearly true of India, but of many agrarian societies. Okay, taking property rights and incumbency rights seriously, but separately. The land right is special in being derived from the right to work, the right to subsist on food, the right to shelter. It's a derived right. But it's also special in being two rights. The right to land as incumbency is the protection, above all, of the poor and the weak. The poor sharecropper or landless labourer in West Bengal who has a large factory encroaching on their source of livelihood by taking land to which they have no technical legal compensation rights, not being owners. It is the poor and weak who face this threat. The rich and strong, in the absence of laws protecting legitimate incumbency, would be just fine and dandy. They just use their gundas and their political influence. But legitimate incumbency is a protection above all of the poor and the weak. Second, much more familiarly, legitimate incumbency is in some measure needed for contracts, and contracts support not only activity and investments and profits, but also support the labour of the poor and the tenancy of the poor, essential to their livelihoods. So the land reform issue is how to get governments moving towards more equal opportunity from land without undue threat to those parts of legitimate incumbency which are valid. I come now to the third part of my discussion, which is when legitimate incumbency matters more or less and when equal opportunity matter more or less. First, if they are rights, you can't just weigh them in the balance. They are what John Stuart Mill called, and Isaiah Berlin later discussed, incommensurable. The very groundwork of our existence, we heard on the first day, Mill said. Absolute and not to be traded off against other policy goals. But they're also very difficult to trade off against each other. You can't say, well, legitimate incumbency doesn't matter, just it's owed 3 units are worth 5 units of equal opportunity. You can't do that. But what you can do is find specific contexts of particular land reforms in places and times where one or less is not so important. The first is diminishing returns. If a society has lots and lots of legitimate incumbency, lots of protection of property rights, but very little equality of opportunity, then clearly equality of opportunity at the margin matters more in land law as elsewhere. Second, alternatives to land as a source of advance matter a great deal. In a society where the poor generally advance through education or through migration to urban jobs, then land as a source of farmland anyway, as a source of equal opportunity becomes somewhat less important. Similarly, if most assets are non-land, increasingly in a developing society, assets become non-land assets, and it is in non-land assets that most legitimate incumbency rests. So you ask, what alternatives are there, as well as what about diminishing returns? Then a very important question, which hasn't been considered here, is the source, recency and origin of land acquisition and its, as it were, genuine legitimacy. That is what legitimacy depends on. I think Mill is not quite right for once when he says that my claim to land cannot be any stronger than the claim of the person who initially stole it. And if land was stolen and I inherit it in the 20th generation, or buy it from someone who inherited it in the 20th generation, my claim is as weak as the claim of the thief. That doesn't seem to me quite right. And to go to the other extreme, land ownership achieved by working new land, as in John Locke's discussion, or land bought in the market from a life of work and saving, the claim to legitimacy of ownership seems to me to have much more force than land that has been ascribed rather than achieved through inheritance for many generations. And indeed, the South African Constitution, Clause 25, which specifies the scope of land reform and the requirements of compensation, makes it quite clear that the history of land acquisition is an important component in deciding how much compensation will be paid and indeed whether land acquisition is feasible. Current and recent land management is also important. If a landowner, let's say an owner of 50 hectares, has been managing that land sustainably and in a way that employs a lot of labor, or else tenanted to a large number of tenants on reasonable and not extortionate terms. If that is the way the land is managed and is productive and sustainable, the case for land reform is obviously weaker than if someone is farming a very small part of his land, letting it all lie fallow and not farming it very well or sustainably. So there are many factors impinging on how important land control is. Now, I would like to make one comment on the evoking of either equal opportunity or legitimate incumbency as a case in the question of land reform. Because it has a strong Indian implication, especially in view of the importance of state land law, which has just been emphasized. Horizontal equity must be secured to the extent possible. That is, people in the same position in different parts of India or with different sorts of soil or water shouldn't be treated differently because of considerations irrelevant to their merit. And that is why we need standard acres. One of the few things where I don't agree with Astha's splendid manuscript, which I was lucky enough to see in advance, is her comment on standard acres. You do need to decide whether a person is a large landowner, not by a crude measurement of size, but by a proper allowance for the quality of land, which of course is not easy. So that is a requirement of horizontal equity. And similarly, when one is distributing land, one needs to be horizontally equitable between people at least in the same state and ideally in the same country, even if in different states. Now, fourth part of what I have to say is the question of getting to yes, negotiating progress towards land reform. Can economists help lawyers? Well, first, ask in general, can the land reform be positive sum? we have been concentrating here on the contentiousness of land, and land is livelihood. Land in Latin America, in many countries, has been so contentious that it's been a matter of 20 and 30 years of war between classes, and I regret to say in sub-Saharan Africa, land is the underpinning of war between tribal groups. So it can be very contentious, but let us ask whether land reform can be positive sum. And here it's been a great contribution of economics to establish that in developing countries with lots of labor and with land, with capital a rather small part of the operation of land and labor a very large part, in developing countries, small farmers produce considerably more per hectare per year than big farmers. It's only fairly recently that that conclusion has come to be generally accepted among economists because of a whole mass of research. The inverse relationship, by the way, that small farms get more out of a given amount of land in labor-intensive developing country circumstances than large farmers, that explains the steady shift of land towards smaller farms. Astha quoted that 1958 National Sample Survey finding from India. Well, ever since then, the proportion of land in farms below 1 hectare and below 2 hectares and so on has been rising gently but very firmly and over the long run quite substantially. And the only reason for that, which makes sense, is the inverse relationship plus the removal, partly by land reform, of the restraints from movement in the marketplace from large holders to small holders. Law has increasingly encouraged that movement, and that movement has happened. But that means that after a time, land reform produces a surplus to be allocated. And in the early period of land reform, certainly until the mid-80s, that wasn't believed. The people who supported land reform in India largely didn't want a universe of small peasant proprietors. Most of them believed, as in the Nagpur Resolution of 1954, in cooperative joint farming. Some even believed in state farming. Luckily, India did not go along that path. There are various reasons which we can go into if you like, why state and collective and even cooperative large-scale farming works particularly badly. India did not go along that route, but the reason, I would say, why that acquired land was not redistributed was that the people who believed in land reform, many of them didn't really believe in the small farmer. But the inverse relationship does create a general possibility for less contentious land reform. Even more so does the fact that after reform, big farmers can gain by selling to small farmers and to land reform beneficiaries. Processing of products such as tea and sugar, access to markets through bulking up. In recent years, information technology. All these things can be sold, extension, all these things can be sold to land reform beneficiaries. And there is again a scope for the big, recognizing that land reform may be in their interests as well as in the interests of the small, and for negotiating a way to yes. Now, the other way I want to look at, apart from the inverse relationship, the other way in which land reform can be agreed and negotiated is that reforms should be incentive compatible. Economists use the expression incentive compatible to describe a piece of government action which produces private responses that help the government's action along towards its goals. And government actions that produce the opposite response, where private individuals are encouraged to act in ways that damage the goals of policy, are incentive incompatible. Now, I think Astha's excellent general point that tenancy reform, because it encouraged resumption for personal cultivation, has proved tenancy incompatible in India, is absolutely true. And I think, incidentally, that it is not correct to say that if there were genuine resumption for personal cultivation and the big landowner farmed all the land himself or herself, that will be okay. It will certainly not be okay for the poor. It will be even worse than if the resumption for personal cultivation used the former tenants, for example, as landless labourers. It would be even worse if the big owner went capital intensive or IT intensive and employed hardly anyone at all. The Australian average farm of 3,000 hectares is not very helpful to the rural poor, although of course most of the poor are not rural anymore in Australia. So there is an absolute incompatibility between tenancy reform and the goals of tenancy reform because of resumption for personal cultivation. But ceilings remove that incompatibility, because if there is a land ceiling and you resume for personal cultivation, everyone can see that it's your land. There's not tenants anymore. You can't say, oh, it's not my land, when the inquirer comes along. So ceilings remove the incompatibility between tenancy reform and the things tenancy reform is supposed to create, namely the well-being of the poor. And ceilings themselves are highly incentive compatible, which is why I think Astha and most people are too harsh on the performance of land redistribution in India. The standard way to look at a land redistribution is to say, oh, the target was to redistribute 10% of land to 20% of poor people. And in fact, only 3% of land has been redistributed, and only 8% of the poor people, the target group, have been benefited. Therefore, it's a failure. The glass is half empty. Okay, well, I think that's a very unsatisfactory way to go about things, but the main point is ceilings are incentive compatible. Ceilings encourage large owners to pass land over to poor relatives, to pass them over to clients, and poor relatives and clients then assert their independence. They also encourage large owners to sell parts of their land to smaller holders or to landless labourers in order to escape the ceiling. In other words, the acts of avoiding the ceiling themselves tend to bring about the consequences of ceilings-based reform. Hence, again, the steady decline in the proportion of land in India that is tied up in very large holdings. That, I think, is a hidden success of ceilings legislation, not foreseen by the people who made it, but nevertheless important. I'll skip most of the rest because of time. But I want finally to throw back the ball. And so I've said that economics can help lawyers and activists looking for good land reform legislation. But I'd also now like to throw back the ball and to ask for some things that economists might request from lawyers. One, address the question of conflicts of rights to reform land. And I speak here from recent experience in South Africa, where there are two processes of reform going on: land restitution to former owners, which has generated a morass of conflicting claims, and land redistribution, which is in a very much more elementary state but is going forward. And having these two together with land restitution creating a mass of competing claim is a recipe for the law's delays in the worst sense, while people go hungry and landless and land goes unused. Secondly, apart from conflicts of rights, I hope lawyers will continue to address the question of conflict of laws. I'll again cite an extreme case from South Africa, but you get the same in many other countries. The Ministry of Agriculture says large holdings are good, we forbid subdivision. The Ministry of Land Reform says small holdings are good, we must get land into the hands of the poor, go on with subdivision of the land. These two laws remain on the statute books, remain in contention, ministries compete. That, I think, is not a good way to proceed with land reform. Third, I'm coming to a close now. Third, look at the case for an amalgamated Agricultural Lands Act. If you have 1,100 land acts, and I should suppose of those 1,100, at least 500 or 600 will affect agricultural lands, lands which are normally agricultural, non-urban lands, do create a special set of problems. If you have a lot of laws with both conflicts of rights and conflicts of laws, the notion, at least at state level, of an amalgamated land act must be considered. Of course, there is a risk that it will delay action, and that needs to be avoided. Now, my final point is about the role in land reform of a very boring subject, parliamentary draftsmanship. And I come back here to the need for all parties, not just economists, to be aware of the incentives created by public action. Every time the draft says, the minister or the ministers designate shall, my ears prick up. I say, who is the minister or the minister designate? Can we be sure that they will always act in the public interest or for the public purpose? There are thousands of ministers designates. Not all of them can be assumed all the time to be always honest. When I hear the minister or designate shall select beneficiaries of reformed land, I start jumping up and down like a pedant who's heard a grammatical mistake, because I see the outcome of this. When I hear at ministerial discretion, land placed in foreign trusts shall be exempt from this or that land law, I say, be careful. So I think there are some things that lawyers might listen to economists with as far as land and land redistribution is concerned, and some things that economists have to listen to lawyers about. Thank you very much.
Thank you, Professor Lipton. May I ask Ramesh Sharma, with considerable experience of land reform legislation, to respond to the findings of the project?
I need a pointer. Namaste to everyone. And first, let me congratulate to Dr. Mustafa, Dr. Amita Dhanda, Astha, Anandita, and the entire team for doing this wonderful research, the subject which is now gradually fading even in the academic world, to bring the whole discourse on land issue here. And I'm extremely thankful for NALSA to giving me this opportunity to share some of our experiences. I belong to a land rights movement, so I bring the whole perspective of land rights movement. When we are talking about the rights, it's also necessary to talk about the wrongs, what's happened wrong in the country. I mean, especially when India has an abusive history of land reforms. We are known for incoherent policy, incorrect, imperfect legislation, and inefficient execution, which is actually symbolized as a total abuse of the history of land reforms in India. It's a very crucial time. On the one side, we are talking about the land redistribution, but at the same time, government is also very much interested to bring a land leasing act, which is completely total bypass of land redistribution in India. So, especially in a country like India, where less than 3% people are benefited out of the entire more than 1,100 legislation in the last 70 years, the land is definitely an important question. So that's why it's also necessary to talk about the land wrongs here. This is the land rights. This is the land reforms. It's a snack and ladder game. On the one day you achieve something, but tomorrow you lose a lot of things. And especially is important in a country like India, if you refer a very recent report of Socio-Economic caste census, which says that close to 56% of the rural population are landless and homeless. The people who don't have any roots in the country. They are nowhere in the political radar. In the previous Planning Commission's document, they were optional extra, and now they are negligible in the whole GDP debate. They are the beneficiaries of Swachh Bharat Abhiyan, of course. But don't forget here that they are the people, these 56% population, they are the one who elect more than 300 members of parliament in the country. So that's why they are a potential political mass to decide. Every year they vote something, they vote for their good faith, so that tomorrow the political party do something, but it's not happened. I mean, the failure of land reforms in this country is, I personally feel, is a failure, it's a collective responsibility of all of us. It's a failure of ours also. It's a failure of a social movement to some extent. It's a failure of opinion maker, elected representatives, labor unions, and the state institutions too. Because somehow we fail to convert the people's wisdom into the political mandate. So until and unless we are not able to create a critical mass who can vote for the land, I think talking about the land reforms and talking about the land reforms, it's far beyond our capacities. Without land, where should I feel my roots? So land is not just a piece of land, but it's a strong symbol of dignity, identity, and livelihood. Especially, it's important in a country like India, where the whole identity of the people or the identity of the deprived community is reduced in voter ID and Aadhaar and BPL card and APL card and ration card and job cards. What about the land? So, the one very shocking figure, which is actually given by National Federation of Dalit Land Rights Movement in 2011, after their long research for 2 years in the whole country, they find 29,000 villages. Please underline, more than 29,000 villages in the country, they don't have any graveyard land in the village. So whenever somebody has died in the village, people are fighting where to dispose of the dead bodies. So this is the level of land redistribution in the country, and this is the alarming situation of land rights on the ground. Sorry. It's very fast. So when we talk about the land, the whole question of land redistribution, let me give you some concrete example from the ground. Sometime we felt that the land laws as a popular slogan and execution is a political choice. Take two examples. One is Punjab, where Shamlat land, which is actually the 1/3 of the Shamlat land, that means close to 51,000 hectares of land is actually reserved for the Dalit communities. Till today, they don't have rights over any inch of land in Punjab. Take example of Tamil Nadu, where Panchami land is actually recognized 100 years back. Justice Chandru has given a wonderful judgment on that. But what about the execution in Tamil Nadu? So there are several other examples. The Assam is also very interesting example, where in the mid-60s, there was an amendment in the legislation and which actually given a safeguard for rehabilitation and resettlement of the erosion-affected communities. But they were never been rehabilitated. In Maharashtra, Mahabharatan land. In Andhra Pradesh and Telangana, DC land. In Chhattisgarh, Rajmahal land. So these are all very distinct set of land which was designated to the particular community, but it's never reached to those people. So that's how we keep saying that land laws as a popular slogan and execution is a political choice. Let's talk about the litigations. Astha has actually mentioned about the whole set of laws which is contradictory, and because of the contradictory legislation, there are huge amount of cases pending in different courts. Take a two very concrete example. Tribal land alienation. If you refer to 2009 report of the Government of India, which states in Madhya Pradesh, out of the total cases pending in different courts, related with the tribal land alienation, 55% claims are rejected and 40% are pending. So hardly 10% cases out of the total tribal land alienation is actually reached to the beneficiaries. In Orissa, 60% such cases are pending. In Assam, 62% cases are pending. And that shows the inefficacious execution of the restoration legislations. So restoration legislations are very much is an integral part of the whole revenue system, but it's never been reached. Take example of sealing, which actually you talked about in a very detail. More than 460,000 cases are pending in different courts, and majority of 36% cases are related with the Dalit community. More than 15% cases related with the sealing laws is actually directly directed to the tribal people. So the bypassing the whole legal safeguard is a real issue, and especially in the time where we have a very good atrocities, the prohibition of atrocities legislation, but most of these land-related cases has never been brought under this purview. The second is all about the absence of the time frame. These cases are pending for years. Sometimes it's a kind of a generational question. You file the case and probably your children may get some justice or not. The third is also a very big challenge for a very interesting legislation, Legal Services Authority Act of 1987. But what these legal services authorities are doing, I mean, the land question is not sometimes even in the purview of the Legal Services Authority. So it's very difficult to bring this whole idea of land reforms in the Legal Services Authority framework. And the final is an extremely big burden on the subsistence rural economy, because the poor people who don't have any money in their pocket, they are forced to fight in the court and paying a huge amount of money to the lawyers and for indefinite. The third one, which is a very interesting subject here, and I definitely want Astha to bring this whole discourse in the research, maybe in future, the land redistribution to the urban poor. What about the urban poor? In 1976, very interesting example, when Indra Kumar Gujral was the Minister of Housing, he bring an interesting legislation called Urban Land Ceiling Act. And I read the first line of this legislation, reducing the prices and increasing the availability of land for the poor, okay? In 1997, when he became a Prime Minister of India, he bring a proposal to repeal this act. And again, I quote the first line of the amendment, which says, reduce the prices and increase the land availability for the urban India. So only one word is missing called poor. And that changed the whole political discourse in the country. In 64 cities, out of the Urban Land Ceiling Act, nearly 220,000 hectares of land were identified, but hardly 19,000 acres was actually acquired for the urban poor. And out of this 19,000 hectares of land, less than 5% land is actually redistributed to the urban poor. And that shows the very damn failure of this land ceiling legislation. But how this land is actually used. Take a classic example of Mumbai. 25,000 acres is actually acquired in Mumbai. And out of these 25,000 acres, 15,000 was a coastal zone and on the forest land. In 2009, when Jawaharlal Nehru Urban Renewable Mission came, this 15,000 acres of land is actually transferred for Mumbai Trans-Harbour Link, Mumbai Metro Project, Bandra Worli and Worli Nariman Point Ceiling, and Mumbai Urban Transport Project 2. So the whole repeal of Urban Land Ceiling Act is actually brings a lot of problem on the ground. According to our own research, we did a research on the data of the Registrar General of Census, and we find that 52,000 villages are wiped out from the map of India in last 3 decades. And they are the poor who become a cheap labor in the cities. The last one is a policy vacuum. I mean, we are living in the time when there is no land reforms policy in the country. We keep fighting, Ekta Parishad keep fighting for the land reforms policy since almost a decade. By refusing the land reforms policy, actually government want to bring the whole idea of encouraging land speculation. Not only in the rural area, but in the rural urban periphery also. And I definitely want to quote here the famous statement of Raghuram Rajan when he delivered his speech in Mumbai in 2010. He said that the whole land market, the open land market and the land speculation and the whole real estate business is one of the biggest source of black economy. So land is an unfinished agenda. And when we talked about the land redistribution, we have also talked about the land which is actually transferred for the big projects. There are the data which is given by Center for Science and Environment, Ministry of Environment and Forests, and our own research based on the Registrar General of Census, which says that huge amount of land is actually given to those people who are a big landlords, who are the big corporates, who are the big industry, who are the big mining corporations, who are the big real estate. But how much land is actually redistributed? If you take the data which is actually taken from the RTI, from the Department of Land Resources, we can see that less than 3% people are actually benefited out of this. Who are the people who don't have any piece of land? If you again refer the Socio-Economic Caste Census report, which is very alarming report, take example of scheduled caste community, the Punjab, Bihar, Haryana, Tamil Nadu, Kerala, Gujarat, Andhra Pradesh, Madhya Pradesh, Maharashtra, West Bengal, and Orissa. They are above the national average. National average is 54%, but they are above 54%. So out of even the 1,100 legislation, these people are never been benefited. The same case for the scheduled tribe also. Let me talk about briefly those people who are nowhere in the political radar, who are nowhere even in the periphery of the whole land distribution debate, the nomads. The Balkrishna Renke report said that close to 10 crore plus population are notified tribe, denotified tribe, pastoral community, and semi-pastoral community. And he also mentioned that out of these population, 80% are completely homeless and landless poor who don't have any stake over land. He suggested a Minimum Land Guarantee Act, but that report has completely shut down and it's thrown somewhere in the dustbin. The tea tribes of Assam, the ethno-linguistic minority, 17% population, don't have any right over a piece of land. Salt workers, close to 2 lakhs of population in the entire country, especially in the state like Gujarat, Rajasthan, Andhra Pradesh and Tamil Nadu, no rights. Fisher folks, 40 million people, nowhere in the radar of the land redistribution. Single women, the huge population. If you again refer the 2011 census report, which says that in 5 topmost states, Uttar Pradesh, Maharashtra, Andhra Pradesh, West Bengal and Tamil Nadu, close to 3.2 crores are single women. And out of them, majority of them they have no security over land tenure. So this is a big question. If we map the whole land conflict in India, it shows a very interesting dynamics. But let me talk about the final thing, which is, I guess we need to again and again debate this issue. We keep talking about the land acquisition. Nowadays, we are talking about the land pooling. But what about the land diversion, which is happening very silently? Just in one notification, you denotify hundreds of villages. Just in one stroke. In Bhubaneswar, recently 210 villages were denotified because urban municipalities are expanding. Take example of Raigad in Chhattisgarh. Take example of Nagpur. Take example of Bhopal or Gwalior. So out of this expansion of more than 12,000 urban settlements, we lost more than 52,000 villages. Every year we are converting close to 758 billion square feet of land into the concrete jungle. Yes, we are retailing the reforms because nowadays, I'm just closing in just 1 minute. 1 minute. So we are talking about the retailing of reforms because nowadays there's no discussion about the fundamental rights like land, but we are retailing by giving a charity. It's a political charity because housing for all by 2022 is a good political jumla, but what about the roadmap of housing for all by 2022? We keep talking about the land guarantee legislation, homestead guarantee legislation. Few states have some examples, but these are all schemes. These are not legislations, except in Madhya Pradesh. Because of our hard effort, at least in Madhya Pradesh, there is a land guarantee legislation. So it's a high time for us to keep talking about this whole debate. Next action, of course, we keep talk about the land guarantee legislation, Women Farmer Entitlement Act, which is completely forgotten after 2011, land reforms policy and the land reforms commission, which was constituted. I'm very happy that Walter Fernandes ji here, who is also one of the member of National Land Reforms Council, possibly you still remember that. Prime Minister is the chairperson, 12 chief ministers are the member, 7 cabinet ministers are the member. Not a single meeting has happened since last 10 years. So this is the example. And this is the solution. Millions can walk. Next year, in October, 10 million people will mobilize in the entire country. We try to bring again land agenda in the political discourse. Thank you.
Thank you, Ramesh Sharma. These are indeed grim figures. May I now call upon Professor John Reid to respond to the project finding in light of indigenous and treaty rights in Northeastern America, North America. Canada. North America, Canada.
Thank you very much. My PowerPoint.
John, do you mind?
Well, yes, I was wondering about. Here.
That's better.
Perfect. Yeah. Well, let me begin first of all. How exactly does this work? Here we go. Let me begin, first of all, by, as others have, thanking the organizers of the conference. It's a wonderful event, already has been so, and I'm delighted to be part of it. My task is to provide, in a sense, a comparative perspective. And what I want to do is to say a few words about land and indigeneity in a Canadian perspective, and in particular, in one particular part of Canada that I will define in just a moment, according to the map that you can see. Let me begin by saying that I am not an Indigenous person, and it's important to acknowledge that because clearly there are insights that I do not have because I'm not part of that community. I'm also not a lawyer, and I am a practicing historian. And I'd like to join with Professor Lipton in saying that one of the things that I really welcome about this event is the interdisciplinarity, and indeed historians and lawyers need to speak to each other, I think, more than we do at present. So in that context, I want to focus especially as an example on indigeneity and land in a particular part of what's now Canada, usually known as Atlantic Canada, which, as you can see, is at the extreme east of the map here, marked in a kind of sand color there. And these areas are the homelands of three principal indigenous groups, the Mi'kmaq, the Maliseet, and the Passamaquoddy. And for these peoples, historically and today, issues of land and issues of resources are really inextricably tied together. They're tied together in ways that I will suggest to you can only be understood in a historical context. And one of the points that I'd like to make throughout this presentation is that history matters. And of course you're thinking that I'm a historian, so I have to say that, and that's true. But I do hope to make the point that history does matter. And secondly, to make the point that in a context particularly of settler colonial societies, of which Canada is one, like, for example, Australia and New Zealand, in a context of settler colonial societies, land and indigeneity are inextricably tied together as important areas. So those are the two general points that I'd like to make. Let me offer you a historical timeline, and I'll leave this up on the screen. This will be my last actual part of the PowerPoint presentation. But I'd like to spend a few minutes just examining some of the sequences of events across a number of centuries that have led up to the way in which land and indigenous questions are tied together in 2017. The first era, of course, there's an era before then, thousands of years of indigenous societies, but the first contact between indigenous and non-indigenous peoples in this part of North America came about 1500. And yet for another 2 centuries plus, the non-indigenous presence in this part of North America was so marginal, so negligible, that it was self-evident that indigenous societies were central and that non-indigenous were peripheral. But with the expansion of the non-indigenous presence that began particularly in 1725 with the gradual expansion of the British presence in Mi'kmaq and the other indigenous homelands, came an era of some almost 6 decades when the relationship was one of a political relationship that can be defined as friendship, particularly expressed in treaties. And between 1725 and 1782, a series of treaties were signed between indigenous people and the British Crown that were treaties defined as treaties of peace and friendship. So that friendship as a political relationship prevailed in those years. Now, what's critical about the treaties that were signed between these indigenous peoples and the British Crown is that none of these treaties involved a surrender of land. There were treaties in what became Canada further west that did involve surrenders of land, even though they were often questionable in terms of the nature of the surrender. But the treaties in this part of North America did not surrender land. There was no dealing of land issues in the treaties. And indeed, in 1763, the Royal Proclamation of 1763 that affected all of the then British claimed territories in North America set down a procedure for possible land surrender, and that procedure was never followed in the homelands of the Mi'kmaq, Maliseet, or Passamaquoddy peoples. So the point that I make to you is that in this era of friendship, there was not only no land surrender in the treaties, but also, even in terms of British legality, there was a process that was never followed, and therefore, even in terms of British legality, there was no land surrender. Now, the next phase was a transitional phase when settlement really did become sufficient to produce environmental change, to disrupt the indigenous economy, and demographically to allow the non-indigenous settlers to outnumber indigenous people, and not only that, but to outnumber the indigenous population by a considerable margin. The result was that through demographic and environmental pressure, settlers essentially appropriated indigenous land. This was done in a way that was crucially tied, again, to these demographic and environmental factors, and not in a legal sense. Now, there was a form of legality through provincial legislation that was the legislation of settler regimes that permitted settler encroachment. But in terms of any kind of legality that related to the treaties or to the Royal Proclamation, there was no legal process. The result was that indigenous populations were squeezed into small reserve areas with very few resources, with overcrowding, malnutrition, tuberculosis, and all that accompanied that process of being relegated to reserves. The impacts were compounded by the imposition in 1876, and we're well into here the era of unrestrained settler colonialism. The Indian Act of the Dominion of Canada in 1876 that sought to regulate indigenous societies, and indeed efforts to erase indigenous societies by means such as cultural means like residential schooling, or by more direct means, such as the effort of the federal government of Canada to clear areas of Western Canada, making deliberate use of hunger and disease as ways of, quote, clearing the land for settlement. But although unrestrained settler colonialism continued well into the 20th century, there were two major developments of the late 20th century. One beginning in the 1960s, the formation of indigenous organizations that addressed land questions as well as resource questions. And secondly, the 1982 Constitution, the Charter of Rights and Freedoms, that specifically enshrined existing Indigenous rights into the Constitution of Canada. And that has led, in the part of Canada that I'm primarily dealing with, to a series of cases that so far have focused mainly on resources, but do carry land implications. The most far-reaching one being the Supreme Court's decision in 1999 in the Donald Marshall case that held that the treaties were not only in full effect, but guaranteed certain important fishing rights to Indigenous people. So again, it's resources, but resources also linked to land. But what this implies, I think, is that in a settler colonial society, while certain rights can be established legally, as through the Supreme Court of Canada, nevertheless there are some continuing problems that impact the question of Indigenous land rights. One of them is the fact that demographically Indigenous people in Canada are less than 5%. So the 95% who are settlers in one way or another essentially lack an understanding of treaty and Indigenous rights. That means that there really is no political incentive for the settler government in Ottawa, the government of Canada, to address Indigenous land rights. And indeed, there are political penalties for any government that would do so. Legal avenues clearly are very important, and in the context of the Constitution, they are critically important. And yet, even in a legal sense, I would suggest to you that there is a lack of philosophical clarity about the nature of Indigenous rights. Are Indigenous rights, as some would argue, essentially privileges that are called rights, but nevertheless really stem from a kind of surrender, historically, and a kind of partial regrant of rights by the Crown. And therefore, while they're called rights, they, according to this view, really can be altered or taken away by the Crown if it wishes to do so. So that's one view. A second view of three that I'll suggest is that these are rights. Indigenous rights to land are rights in a full sense, and they stem from treaties as well as from the longer Indigenous origins. But they are rights that must be established, verified, interpreted through the court system of the Crown, and thus are subject to regulation by the Crown in whatever ways the courts may decide. Or thirdly, as Indigenous organizations would argue, are these indeed fully valid consequences of an inherent continuity from an era prior to imperial encroachment or of a negotiated treaty relationship? And this is the view that takes the treaties most seriously and significantly, and it would accept the treaties in this view as being fully negotiated treaties that do not involve land surrender, and therefore that the settler regime must live with the realities of these rights and treaties. So this is really a national debate that is taking place in Canada, not only in eastern Canada, but a very important national debate that is ongoing. So what I would suggest to you in conclusion is that in many societies, and particularly in settler colonial societies, the relationship between rights and indigeneity is crucial and inescapable. Secondly, that rights proceed in part from the reality that Indigenous societies pre-existed any kind of non-indigenous presence or encroachment. Thirdly, that the peace and friendship treaties are crucial because they pre-existed settler colonialism. They pre-existed the force of environment and demography that reduced indigenous societies to non-productive reserve lands. And finally, what I would suggest to you is that in contexts like this, history matters, chronology matters, and it's crucial in terms of the kind of interface between history and law, to take account of historical development and to take account also of legal realities, treaty and rights related, and to be able to coordinate the two to understand fully the nature of the rights that govern indigeneity and land. Thank you.
Yes, that's right. Yeah, okay, that's better. Friends, first of all, I want to begin by congratulating the team that has done this beautiful study. I was really impressed by it. Thank you for it, and thank you for this opportunity to react to it. I've been asked to deal with the land rights of the tribes, and I'm happy that I'm coming immediately after Professor Reid, who has dealt with the land rights of the Amerindians. And the situation of our tribes is not too different. But why? Okay. I would like to look at three main points. The first is the assumption, and probably it's true, that the central laws overtake state laws, though the state laws matter really in life. But I state that this is true about land acquisition, but not about regular land ownership pattern. And that ownership pattern is governed more by the customary law among the tribes than by any state law. So while discussing land, one has to go beyond the state-centered dynamics to the customary formal law dynamics. And that is what matters. And that is being used both by the tribal elite and by the political elements and those who want to take away their land. The formal law is superimposed on the customary law rather than the central law being imposed on the state law. Now, that is basic both for conflicts around land and for discrimination. and for the tribal rights over land. Now, let's begin with land acquisition. As Jairam Ramesh said in his Sardar Vallabhai lecture 2011, we are speaking about Maoism. In fact, the title is From Tirupati to Pashupati, the Naxalite, the Maoist belt. And he said it is, while speaking about Naxalism as a law and order issue, we forget that the basic issue is not violence, but the rights of the tribes that are violated. Their land is taken away without compensation, without rehabilitation, without their consent, because that is considered state property. The second issue is the ambiguity of land laws. That too is forgotten in the rest of India because that is specific to the Northeast. And the third issue I would like to deal with is the formal customary law interface. That is basic to land alienation, particularly in the Northeast, though to some extent also in Middle India, the tribal India or Central India. Now, it's important mainly for internal tribal land alienation. To begin with CPRs and land acquisition, as Jairam Ramesh said, the Maoist struggles are a reaction to depriving tribals of their land. They are deprived of their land and their rights are ignored in the process. Now, I can vouch for it because we have done studies on land acquisition 1947 to 2010. I mean, displacement, land acquisition and displacement in 15 of India's 29 states, or now it's 16 out of 30 states. And what comes out is that the tribals are deprived of their land without, forget consent, no compensation, no rehabilitation, because the CPRs are considered state property. And that is, in other words, the state alone has rights. The tribes do not have rights over the land they have inhabited for centuries. Then take the case of Orissa. 54% of the land used is CPRs. Tripura, tribes are 31%. They are 65% of displaced persons. Assam, according to them, 3.9 acres of land deprived 3.4 lakh people of their livelihood. 1947 to 2000, the reality is 19.1 lakh people deprived of 14.1 lakh acres. All that is tribal or other common land. Now, so what the state does is to find the cheapest way of acquiring land. The cheapest way is to take away CPRs without compensation, without rehabilitation. So, but effort is being to change even those laws that give them some rights, the Chotmark Tenancy Act, the 5th Schedule. So, but we have to realize here, it's not just the law that matters, but the development paradigm, which looks at development only as infrastructure building and ignores people. And that is basic to, so we have to concentrate more on the social process rather than on land. Despite Article 21, interpreted by the Supreme Court as every citizen's right to a life with justice, with dignity, development ignores it. Now, most tribes, particularly in the Northeast, manage their land by according to their customary law, not under the state law. But that is accepted in theory, but in practice, the policies and projects are imposed on them that change the system completely. Say for example, tea, rubber, coffee plantations are encouraged, but the condition for subsidies and loans is individual land in the name of the head of the family, when their system is community-based. I just give the example of the Garo tribe in Meghalaya. They are a matrilineal tribe. Suddenly the rubber board comes with a scheme for rubber plantation with individual ownership by the head of the family as a condition in a matrilineal community-based tribe. We did a study 30 years later. We found 30% of the families landless and more of land being transferred from the woman who is the inheritor to men understood as heads of families. So what happens with this interface is strengthening of patriarchy and class formation, greater poverty and absentee landlordism. Take Tripura, the law itself was changed to suit the Bangladeshi, East Pakistan migrants who had come in search of land. They are called partition refugees. They are not. 80% of them came after 1950 in search of land. And they took over the government itself. They became the politicians. They became 70% of the population, the Bengali Hindu migrants. And they changed the law to suit their need, to recognize only individual ownership. That was in 1960. Within 10 years, according to studies, 40% of tribal land was lost to them, to the immigrants, between 1960 and 70. And the tribals are rendered landless. They have gone to court. It's the same migrants who manage those courts. Only 8% of the cases, their rights have been recognized, restored, land has been restored, and of these, 2/3 of the land is right in the middle of a Bengali colony. There is no way that tribal can reclaim that land without losing his life. So, in practice, there is a law which is toothless, which cannot really do justice. In the rest of, say, in Assam, 1/3 of the land is patta land, mainly in the urban areas. The rest is what's called exonia patta, annual patta, or common land. So there is a great amount of ambiguity, and that has to be looked at while studying land laws, particularly in the Northeast. The land laws in Assam are based on the Burmese, the Ahom Burmese system, according to which all land belonged to the state, and the king distributed land to each family in return for one month of labor. The British took that law, but took only the first part of the law. All land belongs to the state. And that has become, in practice, the law in the Northeast and in Burma. Burma, the present constitution still continues that system. So its result is that encroachment becomes easy. We blame the Bihari and Bangladeshi immigrants for coming and encroaching on land, but they are the push factor, all right. But the pull factor is legal ambiguity, which makes encroachment on land easy. Much land is lost, and that is the cause of conflict. In the development itself, the focus is on big institutions and highways between cities and linking ASEAN. The rural areas are neglected. So for to send children to colleges in the urban areas or outside the Northeast, parents have to sell their land to some rich farmers, rich members of the tribe. Or it's worse when it's a question of health care. In a health emergency, they have to sell the best land at a throwaway price. So that has become a massive source of land alienation. So I believe that we cannot look at only the law. We have to look at the social processes. First of all, that the development paradigm that focuses on the infrastructure and on the urban areas. Secondly, the whole concept of changeover of land from sustenance to commodity. And the tribal elite has internalized that value system. And the class aspect, so only change of laws cannot stop land alienation. It can, at most, support change of attitudes if there is a law that goes together with social change. And I feel that particularly in the tribal areas, one has to look at the combination of the domination dependency syndrome. Those who are trying to occupy their land are strong, and the tribes are unable to resist that, the strong. Two, the whole social process of changeover of land as from commodity to property. Three, the whole issue of changing laws to suit the needs of the encroachers. And the law can help change if it goes together with these processes. Thank you.
Good morning. I am bad substitute for Professor M.P. Singh, who is an established authority on constitutional law and was rightly made recently Professor Emeritus at Delhi Law Faculty. I am just a student of constitutional law, and it's an interesting story how I became that student and then started teaching. Two teachers of constitutional law passed away, and two left for abroad, and there was nobody to teach. And the dean came to me and said, all seniors have refused to teach, and you are the junior most, so you have to teach. Now at Nalsar, what really happens that Professor Dhana decides who will teach what. And therefore she thought that I am to replace Professor M.P. Singh. I really am scared of her that someday she will ask me to teach CPC or taxation. Next question. So my only justification somewhat of standing here is that I was taught right to property by very eminent constitutional law teacher in Aligarh, Professor V.S. Rekhi, who has himself worked on right to property. And I was taught history by an equally eminent historian, Professor Irfan Habib and Professor Shireen Muswi. And then the treatise about which John Reid was talking about, he taught me in Halifax that the land was not surrendered by the indigenous people, and he is here. Now, coming to Astha's work, in the last 6 months, the country has been debating Muslim personal law and triple divorce. So the whole problem of Muslim personal law, as you know, is this, that these people are saying maybe something is Quran, we don't care about Quran. Whatever our master says, we will follow. And master in personal law means the leader of the particular denominational school. So say if it is a Hanafi school, so Imam Abu Hanifa is the master, and then rest, he had two particular disciples, Imam Yusuf and Imam Muhammad. So the rigidity in law has come in because you have such great students who said, whatever master has said is final, we will not look even in the sacred text. At Nalsar, it's the other way around. I have taught Astha, but I am the one who is going to entirely agree with her, and it is after many, many years that on the question of land, I read something which is consistent with my ideology, and both of us are on the same page. So I must compliment that it's a remarkable work, and in reinitiating this debate as to the distinction between right to property and land is not a property, I believe that Astha has done something very, very remarkable. And in studying these different laws, you know, she was saying just now that in Telangana and Andhra Pradesh itself, if you had 200 laws and you have these many states, so what kind of work she must have done. And she is right to a very large extent, as she says in the very first page of her study, that my task was to make somewhat land law less boring. You have made it very, very interesting, Astha, I must tell you. Now, broadly speaking, as you must have noted from her presentation, she has raised following issues, and I will react to them a little bit. And the main issue is this, whether land rights are different from property rights, which is her central question. So she says that land is intricately associated with the lives of millions, and a number of other panelists have agreed with her, and thus must be treated differently from other properties. Relations around land, according to her, are fundamental and represent the manifestation of power in our society. And therefore, we must understand what she calls sociology of land. I entirely agree with her. Land does not represent singular economic activity, but several dimensions which law did not fully understand. You heard that the subsequent panelists were elaborating this whole thing. Now, property right or ownership of property, she says, must be something that can be owned and about whom you have bundle of rights, including right of alienation. In fact, that is the primary right if you are an owner. The right, according to her, if extended to land, would lead to disparity in terms of liberty. Owners have liberty in respect of land. They can alienate it, they can transfer it. Non-owners have no liberty or rights in respect of lands on whom their livelihood depends. And politics of representation, as my predecessor was just saying, gives landowners a major say in lawmaking. So what kind of laws will be made? These are powerful people. In fact, in the Constituent Assembly debates, Govind Pallav Pant exactly said this when the debate took place, that these big zamindars will have best of the brains, best of the resources to assert their right, and we will not be able to fulfill our commitment of distributing land to the tiller and the landless. She also talks of parliament and judiciary converting this whole debate into the question of their supremacy, into the question of jurisdiction, as to the interpretation of constitutional provisions, and then did not talk about contents of these laws. Now, she is very right when she says that since so many people depend on land, there is a very strong case for redistribution of land. And to get it done, she is willing to take us beyond liberal notion of individualism, even though this is a little problematic. And with Professor Neera Chandhoke here, how much of individualism we are willing to surrender, but okay. What she is arguing that there has to be a harmonious reading of right to property and right to livelihood of cultivators. And in this redistribution, and here I am in agreement with her, principles of equality, fairness, and non-arbitrariness should be the guiding principle. With privacy judgment, we need to read all fundamental rights together. Now, coming to whatever little I could learn from Professor Irfan Habib, if you look at the whole question of this land right, in ancient India, we don't have much of evidence available to us, but there is one copper plate inscription which talks of land of Brahmin and then percentage of tax. And then this is mentioned by Chinese traveler Huang Song, and it shows that landowners enjoyed the option of cultivating their land through hired servants and laborers or getting them cultivated by peasants on sharecropping basis. So peasants cultivated the land and surrendered the part of produce to the king's men, intermediaries or others, but they were not the owners of the land. So there is substantial evidence, even from ancient India, that peasants were tied to the villages. Though the existence of serfdom or the bondage to an individual landlord is disputable, the history of transfer of physical rights begins with Shakas and Satvana rulers' grants to Brahmins in Maharashtra in the early 2nd century. Grants on similar terms to the rulers, kingmen, vassals, and officials appear much later at the 8th century, or they became numerous in the 11th century, when you got these clan monarchies, kingdoms divided among members of the royal clans. About Bihar, Professor R.S. Sharma, Professor Bakshi was talking about him yesterday. He says land will go along with cultivation. So peasants who ran away from the land, they are to be brought back to the land. They have to work on that land. And then whatever crop will come, some share will go in the land revenue. So even peasants did not have the right to destroy the land or right to refuse that they will not work on land. Now, French traveler Francis Bernier, who was in India between 1656 and 1668, and this is the Mughal period, as you know, let us look at the question, and he looks at it, whether Mughal state was similar to European states whose main function was protection of private property. And even according to him, such was not the case in India, and indeed in Asia in general. And according to Bernier, this was the sole reason of all economic problems in Asian countries. And that's why the British will introduce their own concept. And therefore, he talks of intense oppression of Jagirdars and revenue farmers who were aware, and this is very important, who were aware that their own title to revenue in any village was only temporary, as it is derived from king who might deprive them of control over it at any moment. So they were not the masters of the land. As I am going to show that they were the officers. They were getting this land in lieu of salary, and that's why they were routinely transferred. In fact, there is a farman available of Aurangzeb to Rasik Das issued in 1666, where he draws a picture of declining agriculture and oppression and oppressive taxation. Mughal kings, as such, never made any claim of universal land ownership. So even king is not the owner of the land. Even king did not own the land. For purposes of revenue, Mughal state attempted improvement in the land. In Europe, these tasks were performed by large-scale owners, and thus Marx was justified to some extent in perceiving Mughal emperors or Mughal Empire as a system of Asiatic despotism, based on what he calls tax rent, which was different from laissez-faire state, principally in its obligatory concern for protection of agriculture by irrigation and other means. But outside the physical system, the Mughal state interfered little with the structure of property rights, subsisting on secondary claims to the agrarian surplus and on urban houses and merchant capital, and this is important why I'm bringing in the urban thing. So there was no ownership of land, land was in abundance, but agricultural land no one owned, so the entire village will own it. It involved chain of rights, not the ownership. The tax during Mughal period was not on land, it was on produce. The claim was on a share in produce. And this claim generally was stated in kind, but paid in cash or partly paid in cash and partly in kind from Alauddin Khilji's time to Sher Shah. So even Delhi Sultanate had this kind of thing. Then Akbar largely made it in cash. And then there are a number of rates of different regions depending upon the fertility. There is a schedule given of rates in Ain-e-Akbari of Abul Fazl. So crown land concept was also unknown to Indians. But there was some land which the king will have for his own consumption, but he will not own it, what was called Khalsa land. And this land was given in the Delhi Sultanate, that is between in the 13th century to 16th century, to the Mukti, who will be having an iqta. So he was a revenue collector, or to the Jagirdar during Mughals. And they involved these intermediaries for the revenue collection because they wanted to eliminate possibility of concealment. And unless you are a local, you will not know that the adequate revenue has been paid. So Jagirdar or intermediaries did not own the land. He was just an officer, and they were transferred during Mughal period every 3-4 years. Even Khalisa land, which was under the control of the king, sometime it will be given to Jagirdar, sometimes Jagirdar's land will become the Khalsa land, and this was all in lieu of salary. And then Todarmal came up with 10 years concept, and then comes up with Sare Hasil, which was a Persian term, which said those who improve land, their rank in the Zamindari and Mansabdari must be improved. So Munim Khan was the Jagirdar of Sambhal, and when he went to Jaunpur, when he returned, it was found that his land has been transferred and he has to go to Punjab. But urban land and houses were owned. The distinction which Astha is making between agricultural land and other properties. And that is why about Taj Mahal you are having so much of controversy. The real history is this: when Shah Jahan wanted to construct Taj Mahal on the bank of Yamuna, there was a Haveli of Jai Singh. And he said, you take one of my Haveli in Lahore and give it to me because ownership is there. And Jai Singh said, no, you can take any Haveli. My Haveli, it will be great pleasure, take it. But Shah Jahan did not concede, and eventually this transfer took place, and the document is available. That Jai Singh took Shah Jahan's Haveli in Lahore and gave his Haveli, and because it was an urban land, so there was no Shiv temple as such to say. This is all nonsense. Now British on the other hand damaged this whole system because they considered these officers of the state, the intermediaries, zamindars, as owners, and transferred these ownership rights to them. And that's why zamindars remained loyal to them. They did not support the freedom movement. They did not join even the 1857 revolt. And that's why we have this whole problem today. Now, whether the reforms which we brought in, just 1 minute, Vivek, has it really helped the poor? And my take is, Astha, that if you look, there is a gap between the 1950 Zamindari abolition laws and the land ceiling laws. In most states, the land ceiling laws will come in 70s. And in the land ceiling laws, when Zamindari was abolished, there was already an alert given to these people. And then you are having some 15, 20 years. So many Benami transactions took place, and therefore there was not much surplus land which will be taken out. Okay, subsequently you did something, passed some law on Benami transactions. But if you look even at the land ceiling laws of more states, the real devil is in details. And therefore there were exemptions. If it is an industrial land, if you are having a garden on this or a grove, it will not be taken. And that's why very little land was really available. If I can give you quickly the figures, we have so far in all the states taken together, the land which we have given to poor is of the size of Goa, which is our smallest state. And we have given very small land, less than 1 hectare we have given to people. And over the decades, this number is also going down every year. Every year, the land which is available is also going down. And that's why it is not sustainable for people to even cultivate and live that. In fact, the land acquired total is of the size of Gujarat. The land given eventually was of the size of Goa. And that's why you have a whole problem. Therefore, I feel that in conclusion, Astha is very right, that while we can learn from some states like Kerala, AP, Karnataka, who establish land tribunals, so speed up disputes, but we must address the central issue, that the ownership of land is not of anybody. It's a common ownership. and that's why land distribution must take place. Thank you very much.
Thank you, Mr. Vice Chancellor. Well, the responses to the project have raised even more questions than I think the project had taken on board. And I am going to now ask the audience to respond. I have an obligation to make one random comment. You know, I don't think I'll be able to speak for 15 minutes. It's quite outside my competence. You know, the discussion around the report of the project highlights precisely the philosophy that institutions like NALSA embody, that law is embedded in social and power relations, and it creates new power relations or reinforces old ones, and also created swords of deprivation. And as I was listening across the board to various respondents, it struck me that if we were to look at the impact of the permanent settlement in Bengal, there are two films, classic films, that capture the contradictoriness of the permanent settlement. One is Bimal Roy's Do Biga Zameen. And we are very, at least my generation was brought up to the 50s film, I think, of Balrat Sani, who used to be a small landowner, now manually pulling a rickshaw. The other film that captured the nature of the very degenerate, deprived landlord class that had come into existence was Sahib Bibi Ghulam by Guru Dutt. These two films very powerfully illustrate social consequences of land resettlement. We could add Devdas, I suppose, Bimal Roy's Devdas, not the Shah Rukh Khan one. But, you know, the creation of an elite that doesn't do any productive work and whose children fritter away their money on wine, women, and song. These contradictory natures of land resettlement have been probably are bound to be repeated again and again, particularly in the implementation of the first generation of land reforms and the transfer of land from one class of acquisitive, appropriative landowners belonging to a particular caste to the tenant farmers who become the new oppressors. And wherever you see Dalit struggles, these are against the intermediate castes who had been suddenly made power holders by a combination of material and now caste power. But I'm going to stop here, and I know there are people in the audience who work with land rights, but let me first ask Professor Upendra Bakshi to make his comment.
I thank you very much for the mics and for the project. I'm delighted. First, I want to say that the movement people on the panel and elsewhere, and I have reference to Walter Fernandes and other presentation, Ramesh Sharma, and other friends, seem to echo what Manmohan Singh, the former Prime Minister, said about the present demonetization in Parliament of India this year. He described demonetization, whether right or wrong, I'm not going to do that, as organized loot and plunder. Now this expression, organized loot and plunder, or Professor Reid's idea of settler deprivation or settler colonialism, aggression, law as an instrument of plunder. Law as plunder comes through very vividly in land reforms and so-called redistribution. But that's the first one. My second point relates to a comprehensive misunderstanding of the project itself. Because if I look at the title of these notes, this is a conversation towards realization of socio-economic rights. Most of the time what Astha said, I've not read the project, and what the Vice Chancellor said, very interesting, he quoted you. But essentially, the Supreme Court of India, through Justice Siddhartha and Justice Subarao in the 70s, distinguished very carefully between land reforms, which were merely or mostly tenurial reforms, and agrarian reforms. So I'm not sure what your project is about. The conference is about socio-economic rights, which I understand as agrarian reforms, health, education, empowerment, not just tenurial reform, moving from sharecropper to owner of one part and so on. So I'm confused, and you can help me as to what your project is about. And finally, this business of, I'm taking longer time than I should, but I would simply say, please, in the 70s and 80s, the economists used the term loopholes, that agrarian laws had many loopholes. Now, loopholes presumed a jurisprudence, a theory of legislation. When the sealing laws described efficiently run farms or orchards as exemptions from land selling, were there loopholes? Now, let's suppose you knew what the legislature intended. It might, or it was a part of the intention to exempt them. So loopholes are extremely useless term. It is not a properly analyzed concept. I wonder where you were stepping aside. Is a successor to loophole? In other words, you are saying legislation did not mean to redistribute the land, or did not mean to do land reforms, or did you mean to say in the old way that was a loophole? What was it? What was the intention of the legislature? How do you get there? How do you find the intention of the, apart from imputing an intention to legislate, they're different exercise altogether. Imputation and existent are two different things. So conceptually, again, I need some help. Thank you. Sorry for going on.
I suppose we break up at 11:15. Please refrain from making alternative formulations. If you could just address questions to the formulations already made. Yeah.
I'm Sunny Jose from Humanities Department of PITS Pilani, Hyderabad campus. I have two observations. One, the idea about individual land entitlement to the collective ownership, because it's very important for the poor or marginalized communities like fisher folk, where the idea of...
Who is this question for?
It's actually to Ramesh Sharma.
Ramesh Sharma. Okay, we will collect 3 or 4 questions and then I'll ask them to respond.
So this idea of individual land entitlement is actually militate against the idea of collective ownership, in which that fisher communities are actually deeply embedded. In fact, that limits to some extent, because they are not able to use that land as a kind of collateral for getting loan or something like that, but it's also enabling because the land is not being appropriated by some other, for example, in the name of development or something like that. So the second aspect that I would like to that, the land to the tiller effectively has not happened, but what is effectively happened now is land from the tiller. This land from the tiller is happening in terms of 2 ways. One, violating the laws. Again, I'm referring to in the fisher communities, particularly violating the coastal regulation notifications, that a lot of developments are coming up, and also misusing the law by reclassifying, say for example, collective land, gaucher jameen to development and so on and so forth. So any discourse which is not, okay, thank you.
My question is to Walter Fernandes and Mr. Sharma. It is Professor for Walter Fernandes. Is Indian legal system, especially the tribal land related system, is it trying to make common properties more and more private? CPRs, Indian tribal land legislature systems, are they hell-bent a little bit to make common properties more private? To Sharma, my question is a bit political. Why exactly post-80s? because I was in another avatar, was part of that long march to Delhi, was doing something. So, but then why exactly from post 1980s, why the land is not on the radar of redistributive politics or transformative politics?
My question is to Walter Fernandes. I'm just trying to find out the impact of 6th schedule on the autonomous administrative councils in Northeast. We say we the land rights of the tribals. This just I wanted a clarification. And Mr. Ramesh Sharma, in 6th schedule, empowered autonomous councils, district councils in Northeast. We say we the land rights of the tribals. And Ramesh Sharma, Maharashtra, I know personally, the tenants are the members of the cooperative societies. And they get the loans. And when the waiver of loans question comes, actually they are not the owners. The landlords, they manage, each landlord perhaps will have about 500, 1,000 depending on the land holding that he has, tenants, and the loans are taken, they are members of the cooperative societies, and loans are taken in their names, and they manage the waiver of loans, and the entire waiver is knocked off by the landlords.
I have three small observations. One is that apart from the case of England, which was the first mover industrialized society, there is no country in the world which has even become capitalist properly without having redistributive land reform. France became a properly capitalist economy, society only after the French Revolution, when the ordinary people get property rights. And land was redistributed among the people. Similarly, the only countries in the underdeveloped areas which have become capitalist are the countries which have had redistributed land reform. South Korea, Taiwan, and China had it earlier on. Now it is becoming a ferociously capitalist economy. So that's one general observation. You cannot have large landowners at the same time poor people without refeudalizing that country, as it has happened in India. It has happened in India because even the Agrarian Reforms Committee report, which the Congress Commission, was buried after independence. Central government never moved towards real land reform. And the point which supplements what Professor Mustafa was saying, that the idea that nobody owned land, but the state owned the land, was used by the British and the others to formulate the theory of Oriental despotism. In fact, that is absolutely not true, because even in the Jataka time, you had Anatha Pindaka buying land from Prince Jetha for Buddha, and he covered all that land with the gold plates. And again, in the Mughal period also, you have Jahangir and Aurangzeb giving land grants to the sannyasis of Mathura. And these are private land grants. And Irfan Habib and Tarapada Mukherjee have very interesting papers on that. And in Rajasthan also, we have records of private land ownership. So while it is true that in most parts of India, you did not have private land ownership, you had in Rajasthan that, you had in some parts of Uttar Pradesh, and you also had Tamil Nadu, as Nobuo Karashima had demonstrated. That's all.
Turn to the panel. Yes, please.
Actually, it is, I think there are two kinds of problems with in relation to land, or probably three. One is the whole question of displacements that are taking place, and in a very big way, not only in terms, not only for infrastructure, but also for industrialization. And that, in Tamil Nadu, for example, there is even a concept of land bank, it's horrible. So they are just displacing the peasants and grabbing land, and that is one kind of problem. The other is, of course, the whole question of land reform, redistribution of land, which is what we are, I think the study must have focused on. And even in that, we have a few very important issues. One is the recent, policy and the rule in the whole Prevention of Atrocities Act and the rules. Now the victims of atrocities should be given land. That is, I think, an important thing. And the other that we have been demanding is that the released bonded laborers. In fact, what is happening to bonded laborers who have been released either through the Supreme Court, intervention or otherwise, is that the released bonded laborers are getting back to second bondage. And if we really have to deal with bondage in this country, the distribution of land becomes the most important thing. And last but not the least is the urban land issues which Ramesh Sharma ji had raised. I think the urban land issue or the rural land issue, I think this grabbing by politicians, I think is a very important issue. And the Urban Land Ceiling Act, and all the lands which have got acquired in the city of Chennai, for example, is about 12 acres, 12 square kilometers, many acres, all with politicians. So how do we deal with it?
It's basically, I think, agreeing with Professor Lipton in terms of, because one thing that I heard throughout the panel is a declaration almost that land reforms are a failure. And I want to bring back this point of incentive compatibility that Professor Lipton brought up. In a couple of studies that we have done, I think we can conclusively prove that legislations like the Urban Land Ceiling Act should not be measured only by the amount of land that has been acquired and redistributed by the state. That's one frame. But I think we need to look at that particular moment, how strong a disincentive was created by the Urban Land Ceiling Act and the kind of impacts that had on creating affordable housing at that particular moment. So I think.
Democratic, there's another session. So in the interest of democracy, let me be authoritarian. Okay, 3 minutes.
Yeah, I'll take less than that. One, the first question is the legal system trying to make CPRs private? I would make a distinction between pre-liberalization and post-liberalization era. Pre-liberalization, definitely. In order to distribute, in any case, the CPRs were considered primitive types. So, and that was state property. But post-liberalization, the private sector seems to want security, land acquisition without encumbrances. So the World Bank push today is for computerization, but computerization as is varies. So where there is plenty of private CPRs, they would like to keep it as it is so that land can be taken over without encumbrances. I mean, that's my interpretation of the processes. The lawyers may disagree with that. Sixth schedule, does it deal with land? Paragraph 3 of the sixth schedule is on land. However, more and more sixth schedule autonomous district councils have been created in the last few years without paragraph 3. or more and more autonomous district council are being created outside the 6th schedule. So the land, which is the major area of conflict in the Northeast, is being left out of the 6th schedule in practice. Am I? No. Then the whole issue of land banks, not Tamil Nadu, it began with Andhra Pradesh. Andhra Pradesh was the first to take that, do that, have also the amendment to to give land to the what you call industrial enterprise, industrial areas, industrial estates, etc., to give land in practice to the private sector. That has become the norm in many states today, including Jharkhand has it, Karnataka, Tamil Nadu, and I think that's very dangerous.
Thank you. Thank you for a very interesting set of comments and discussion. I just want to put one figure into your heads, if I may. The proportion of farmland in rural India, which was farmed in holdings of less than 1 hectare, in 1969 was 7%. In 2003, it was 22%. You get very similar results if you look at other cut-offs than 1 hectare. So there was an enormous rise in the proportion of land farmed in small holdings by the poor, almost all of it. Some of that was due to ceilings, not very much directly. Quite a lot, I can tell you, was due to ceilings indirectly, not only through the processes I've described, but also if you look at an excellent book on land reform in Bihar by Uganda and Gopal Iyer. Now, many of you, if you hear the words land reform in Bihar, you'll say, oh, what nonsense. Bihar is the very antithesis. It's nonsense, land reform. But nevertheless, here and there, in quite a lot of places, some activist groups came along, some district officers came along, and they said, here are these land laws which have been a mockery. Let's start to do something about them. Ceilings are permissive. They create a climate of law, exactly the same way that laws against race discrimination, even if they're ignored, create an environment and a climate that can be used and exploited later. So I say, please don't run down the Indian performance too much. Yes, many of those loopholes were built in, were intended by the lawmakers to provide the opportunities for avoidance and evasion. But people are ingenious. If the laws are there, particularly ceilings laws, and the incentives they create are there, then you may sometimes, with ingenuity, get the results you want. One other small point. Again, what does economics show? I want to make clear that the economic evidence does not support a general opposition to common or whatever you call it, land tenure, land ownership, as being bad for productivity. Almost all the studies show that given the nature and quality of the land and the way that land is operated, whether the rules of ownership are communal or individual makes very little difference either to productivity or perhaps more surprisingly to investment. Obviously, if you try and operate cropland in common, you have very, very serious difficulties indeed. But as far as ownership or control is concerned, it seems not to make a lot of difference.
Thank you. Thank you. Yeah. Just to highlight some of the questions and what we have experienced in our activism. I mean, soon after independence, there was a very popular slogan, let's make every landless as a farmer. Sabhi bhumihinon ko kisan bana hai. And what we are doing right now, we are making every farmer as a landless. So this is the one big shift, and it's an outcome of the all manipulations of the whole land reforms question. And especially, this is the time when we are facing this whole second generation of landless poor because of the many levels of acquisition, land pooling, land transfer, etc. So coming back to your question about the whole CPR, I mean, according to our experiences, it could be kind of a very local specific issues. Take an example. If you talked about the all Dalit poor who have encroached the common property land in the Bundelkhand area or in the Madhya Pradesh or in the Chhattisgarh, there is a growing debate whether to regularize or whether to evict. If we take a reference of the Punjab judgment, we have to evict. So within the Agrarian Land Reforms Committee in 2009, there was a huge debate within the committee what to suggest, whether to suggest for the regularization or whether to suggest to evict all those poor people and that make common property land as a free land. So I don't have any black and white answer, but it could be kind of a very region specific. And why I mention fisherfolk here? Because of our experiences in Chilka, where the 70% of the fishing operation is actually privatized for the big corporations. So the traditional fisher folks are nowhere. And there is a great amount of siltation in the Chilka, so that's why there is no other option for those people who don't have any either piece of land. The second set of question, I just want to bring a loud idea about we are actually reducing the whole framework of rights and justice into the compensation and the concessions. So the fundamental space for not to oppose the land acquisition is finishing, because the most of these new set of reforms and new set of legislation is essentially based on the benefit sharing. Whether to accept, like take example of Mines and Minerals Development and Regulation Act. 26% benefit, whether to accept or reject is your choice. Land Acquisition Act, which totally talked about the compensation. There's no other words is actually used. So the whole reduction in the legislative framework is a problematic, and that is a problematic not in the judicial discourse, but it's a problematic within the movement, because it's create a huge divide within the movement. Some movements, okay, we have to support this Mines and Minerals Development Regulation Act. Other movement says, no, we still want to continue, we still want to fight. So that's one area which we are keep struggling. Regarding the question of the whole political radar and how the land is completely out of the political radar, I fully agree. I mean, that's how I said in my presentation, that the whole failure is a collective responsibilities of all of us, including the social movement and including the movement like us, because we are somehow fail to shape the people's verdict for the land rights. So until we are not able to do that, I don't think that there is a great changes happening somewhere in the political system. And just last, in Orissa in 2005, we have a wonderful experience when we did a long foot march from Kalahandi to Bhubaneswar. Before reaching up to the Tangi, which is close to 90 kilometers from the Bhubaneswar, the state didn't responded. So we given a very interesting slogan. Aage jami, pache vote, nahi jami to nahi vote. First land, then vote. If no land, no vote. So I think we need to bring this kind of very strong political message for the political parties, and that's how it's only possible to bring the land for the poor people. Thank you.
Thank you very much. I'll be brief because I think for me one of the great benefits and pleasures of this conference is to listen and learn, whether it be about the project as a whole, or whether it be, for example, Dr. Fernandes's observations on the global issues facing indigenous tribal peoples in many parts of the world. I would simply observe, I think, and it perhaps comes partly out of the points that have been made from the audience, that in thinking about structures of law, particularly as they're affected by legislation, and clearly I recognize that there are many kinds of legality of formal or informal kinds, but in terms of law as it relates to legislation, and others have made this point before, that it's very important to look at the legislators, and what their motivations and incentives may be. And while it's certainly true that legislators who wield socioeconomic power will legislate in that context, it's also very important, I think, to recognize the role of aspiring legislators, particularly in settler societies where legislators may not yet wield extensive socioeconomic power, but see their role as legislators as a way of aspiring to that kind of power. And that too, I think, can be very powerful in areas such as land and the way in which land is used and allocated. With that, I simply again indicate on my part what a very interesting session this has been, and as part of such a very interesting event.
Yeah. No, Astha, I think one point which we should emphasize, which has not prominently come, that really what happened on ground. You see, zamindars, big people, they were not themselves doing anything. So there were already people. If I can give you example from UP land law, so as many as 20 categories of people were there on the land. 20 classes of tenure holders, as your land law will say. And our act just reduced it to 3. So same people continue to be there. Hardly no real change on ground happened. The other thing is, in spite of all this, the large farmers today, they are having land which is 45 times bigger than the marginal farmer. It is not the lowest one I am talking. And if I can give you quickly that you have semi-median farmer, marginal farmers, you have 2 categories. So 9.86 acres they have. Then the medium farmers 4.94. And the small one is having 2.47. And all these people who got under your redistribution thing are having less than half an acre. And they have no choice now. They have to leave this land because it can't sustain them anymore and become what Ramesh and others were saying, urban wage earner in some urban areas. So that is the whole problem. Just in a country of our size, 5.8 million people got land. And the land which they got is less than half an acre. And as I said, if you look at each year, what is the surplus land available, how much it will be distributed, that number is going down. So it was in 2002, it was 0.95 acre. 2015, it becomes 0.78 acres. So it's useless, even if you have land distribution, even if your ceiling laws would have succeeded, they would have got this much of land, which is not enough to sustain. And therefore, people will quit cultivation and go to urban areas. What Professor Bakshi is saying, I think there is an interesting point, of course, that how much of the legislative intent, because the legislative intent was very clear. The judgments demonstrate class character of our Supreme Court. They absolutely sided with the property class. They continue to do so, by the way. And the third point on which I will end, if you look on the 2013 Land Acquisition Act, and of course the definition of public purpose and the entire judicial jurisprudence has been what is the market value, what is the just compensation, what is compensation, it will be just an amount. We had whole debate on this and constitutional amendment on these words, compensation, just compensation or an amount, and on public purpose. So the new government first tried to dilute the 2013 law. So as many as 4 or 5 ordinances. Because by that time, the legal advice had not come from Jaitley ji that Rajya Sabha can be made irrelevant. You have a speaker who is going to certify whether it is a money bill or it is a non-money bill. So if it is a money bill, Rajya Sabha will not do anything. But that idea did not occur at that point of time. And therefore, quietly the advice went to state governments. You dilute it. And therefore, if you look at latest Gujarat law and Goa law, last month only in September, land acquisition has become absolutely easy without doing anything. And that is the real danger with which I think Nalsar as a university should be able to educate people and raise this issue. I think we academically need to raise this issue and flag this issue. I'll end here. But just one more. Sir, there are number of mortgage deeds available, sale deeds available of Mughal period, but they are all of urban properties. There is no sale deed or mortgage deed of any agricultural property available.
I just want to make two announcements. One, you've been given a reimbursement form, so whatever local expenses that you kind of had incurred on the home side, just put those in. And if you bought your own ticket, give us your bank details. That's the process that we are following, so we would have that worked out. The other was that one of the speakers in the next panel has gone missing, so we're going to sort of like give you your full half hour, reconvene at 12 o'clock and carry on in that manner. So that was the reason why I was not getting that restless.
So you are surrendering, not asking anybody, you do it now.
Chaliye.